The first letter I got after this case was written on school stationery, folded twice, with a coffee ring on the bottom corner. In the middle of it, the principal wrote, "Mr. Reed still comes early on Fridays to carry the milk crates because he says kids should eat before they try to learn." I read that sentence at my desk and sat with it for a long minute. I want to tell you how we got there. When that file first landed on my desk, it looked like the kind of case people sort too quickly. State v. Daniel Reed, breaking and entering, theft, a damaged rear door at a neighborhood market, missing cash, a store owner with every right to be angry. The charge sheet was dated February 11th, 2025, and the incident itself had happened on January 14th, 2025, at 10:42 p.m. at Torres Family Market, 1847 South Grant Avenue in Columbus, Ohio. The first pages told me what the law needed me to know. Later pages showed me what it did not know yet. I had the police report, security stills, the inventory list, the repair estimate, and the owner's statement. What I did not have was the life that had carried a man to the back door of a small grocery store on a cold Tuesday night and into a choice that harmed someone who had done nothing to deserve it. I want you to subscribe before I keep going, not because what I'm about to tell you is dramatic, because it is the opposite of dramatic, and those are the stories that need the most people to hear them. Subscribe and turn on notifications. Then let me continue. Daniel Reed was 34 years old when he stood in front of me. The first thing I noticed was that one button on his shirt cuff was fastened through the wrong hole. It made the sleeve sit crooked against his wrist. Before he sat down at counsel table, he turned halfway toward the second row and gave one small nod to the little girl sitting there with a purple notebook in her lap. He did it fast, almost like he hoped no one would see. I saw it. He did not carry himself like a man trying to charm the room. I am always careful about that. People can perform fear. They can perform regret. What I saw in him that morning was smaller and more useful than a performance. He kept checking whether the child behind him could still see him whenever the lawyer stood up. Not because it helped his case, because he was her father before he was anything else in that room. The victim was Elena Torres, 51 years old, owner of the market her parents had opened in 1998. She walked in carrying a flat manila folder with repair invoices clipped inside and a legal pad covered in neat blue handwriting. She placed the folder on the table with both hands, squared it to the edge, and sat without taking her coat off. That told me something too. She had come to be exact. When she spoke, she did not ask me for the most punishment I could give. Some victims want the maximum. Some do not. Neither choice tells me everything. What mattered was how clearly she understood what she actually needed. She said, "Judge, I need my money back. I need my door fixed. And I need to know this does not happen to the next store owner on this block." That was not softness. That was clarity. Later, when the prosecutor asked whether she wanted Daniel sent away for as long as possible, she took a second before answering. Then she said, "I want him stopped. If prison is the only way, then do that. If it is not, do not pretend it is." I wrote that down, not because it decided anything for me, because it narrowed the work to what it really was. Subscribe before I keep going. I am still thinking about what this case taught me. Subscribe, because before this video ends, I am going to try to say it out loud, and I want you to be here when I do. Subscribe now. The incident itself was plain enough on paper, and plain enough in court once everyone had finished speaking. On January 14th, 2025, at 10:42 p.m., Daniel Reed walked into the alley behind Torres Family Market on South Grant Avenue. The rear camera caught him there for 9 seconds. Then he kicked the lower panel of the back door twice, shattered the lock frame, stepped inside, and took 408 tillerns from a cash box, groceries, cold medicine, and batteries. Police stopped him 2 blocks east on Markeson Avenue at 10:58 p.m. That is the harm. A real business, a real woman, a real loss. Ms. Torres got the alert on her phone from the security app, drove to the store herself, saw the broken door, and spent the next morning sweeping glass before opening for the breakfast crowd. Those facts did not shrink because Daniel had his own hardships. They stayed exactly what they were. When he testified later, he did not try to blur what he had done. He said, "I knew that door belonged to someone and I kicked it anyway." I listened carefully when he said it, People tell on themselves in both directions. They tell you when they are hiding. They tell you when they are finally done hiding. Before sentencing, I used one tool I was grateful to have. I ordered a full presentence investigation and continued the hearing for 21 days. In plain language, that meant I told probation to look past the arrest and give me a deeper picture. Work history, housing, family obligations, school records if relevant, victim impact, ability to pay, and the parts of a person's life that never make it into a police report. In this case, discretion meant something specific. Daniel had pleaded guilty to a fifth-degree felony. Under the law, I had a range. I could send him to prison. I could place him on community control with strict conditions. My discretion was not freedom to do whatever felt nice. It was permission to choose the most exact lawful response once I knew enough to make that choice honestly. From the bench, entrances tell me things files never do. Daniel came in through the side door behind his lawyer, but before he sat, he looked back toward the public benches as if counting. He was making sure someone had made it. Ms. Torres entered from the main aisle carrying that same folder, and she never looked at Daniel until she reached her seat. The little girl came in between them, though not physically. She sat in the second row with a woman I later learned was Daniel's older sister, Patrice. Her shoes did not reach the floor. She swung one foot once, then stopped, as if someone had told her not to. She pressed the purple notebook flat against both knees. Most of the room was watching counsel table. I kept noticing her. The first turn in the case did not arrive with a speech. It arrived in a sentence from the probation officer, LaToya Green, during the pre-sentence hearing. She was explaining her interview with Daniel and the records she had reviewed. In the middle of that, she said, "Most people ask me how much time they are facing. Mr. Reed asked me how much he owed Ms. Torres." That was not legally decisive. Humanly, it mattered. I remember exactly what changed for me when I heard it. Not my duty, not the seriousness of the offense. Those stayed put. What changed was the angle from which I was reading everything else. A person focused only on himself wants to know the size of his own pain. A person who has begun to understand what he did starts measuring the damage outside his own body. That does not finish the work. It begins it. Then there was another small thing. While the lawyers were conferring over an exhibit, Daniel slid a yellow legal pad toward himself and copied the restitution numbers by hand. Door repair, $894.13. Alarm rewiring, $392.30. Cash taken, $418. Groceries and medicine, $67.24. He copied every cent exactly. No one had asked him to do that. He did it the way people write down an address when they know they need to find their way back. Subscribe if you believe that courts are not only places where people are punished. They are also, sometimes not always, but sometimes, places where people are met with something more than they expected. Subscribe for those moments. This is one of them. The evidence kept coming and the case kept getting clearer. Daniel had lost his warehouse job in November of 2024 after the company cut a shift. He picked up day labor when he could. He had been evicted on December 29, 2024, from a one-bedroom apartment on Lockbourne Road. That was proven by the housing record. He and his 8-year-old daughter, Sophia Reed, had spent nights in his truck, then on his sister's couch, then back in the truck when the couch ran out. The second turn came when defense counsel asked if I would allow a brief statement from Sophia. I do not always allow that. I do not like to pull children into adult failures unless there is a very good reason. I asked whether this was rehearsed and whether anyone had pushed her. Counsel said Sophia had asked to speak herself. I looked at the prosecutor. He did not object. I looked at Ms. Torres. She gave one small nod. So I said yes. A bailiff moved the microphone lower. Sophia stood on the brass footrail because she was too short to reach it otherwise. She held that purple notebook against her chest and looked at no one for the first 3 seconds. Then she looked straight at me and said, "My dad told me we were camping in the truck, but we were not camping." The whole room got still in a different way after that. She kept going. Her voice did not shake much. That made it harder to hear. She said, "We slept behind the Blue Star car wash on Parsons because there was a light there, and he said the light meant it was safer. He told me not to tell school because he was scared they would take me away. Then she looked down at the notebook and added, he always gave me the back seat because it was flatter. I took off my glasses because for a moment I could not see the page in front of me clearly enough to pretend I could keep reading. I did not cry loudly. I did not make a scene. I sat very still, put the glasses down beside the file, and let that child finish speaking before I touched anything again. Judges are people in public on their hardest days. That was one of mine. Sophia said one more thing that has stayed with me since. She said, he told me if I stayed in school, we were still a regular family. There are sentences children say that should not have to exist. That was one of them. What made that moment more than sad was that it was backed by facts. Defense then offered attendance records from Southwood Elementary showing Sophia had missed only one day in the 6 weeks around the offense. There was also a shelter intake waitlist confirmation dated January 9, 2025, and a statement from the school counselor saying Daniel had been picking Sophia up on time even while unhoused. The paper itself was ordinary, but the facts on it pointed somewhere I could not ignore. What they pointed to was this: Daniel Reed was not a man without obligations. He was a man carrying them badly, unevenly, and at one terrible point unlawfully, but he was carrying them. That matters when you are deciding whether a sentence can be built around responsibility instead of removal. The defense did something else right that day. Rachel Kim did not ask me to forget the victim. She did not say need made the crime smaller. She said, Judge, if you sentence this case as though only hunger was present, you miss the harm. If you sentence it as though only harm was present, you miss the person you still have a chance to reach. I gave that the weight it deserved. What she got wrong was this. She leaned too hard at one point on desperation, as though desperation had moved Daniel's leg and kicked the door for him. It had not. I said that in court, and I meant it. Desperation can crowd a room. It still does not make the choice for you. Daniel made his own choice. When Daniel spoke for himself, I listened even harder. A defendant's own words are never the whole answer, but they are often the cleanest window you get. He said, I had $32, half a tank of gas, and a kid with a cough in the back seat. I chose wrong. That told me something true about his circumstances. Then he said, Ms. Torres did not put me in that alley. I put myself there. That told me something true about his accountability. Then he said the sentence that decided the direction of the case for me. He said, my daughter has seen me break enough promises. She should see me keep one. That was the moment I knew what I was going to do. I wrote it down, not because I needed to remember it, because I wanted to subscribe. Because if this case surprised me, and it did more than once, I think what comes next will do the same for you. Subscribe and stay with it. There was a memory from my own life that came back to me while he was speaking, and I had not thought about it in years. I was 12. My mother and I spent 2 nights in my Uncle Ray's old Buick after a pipe burst and our apartment was shut down in January. He told me it was temporary and called it an adventure because that is what adults do when they are trying to keep a child from feeling the full edge of a thing. At some point after midnight, I woke up cold and looked through the space between the front seats. My uncle was sitting upright with no coat on, his hands tucked under his arms, watching the windshield fog and clear with each breath. He did not know I was awake. He turned once to make sure I was still covered. Then he looked forward again and stayed there until morning. By then I had enough to see the third turn coming, though I had not spoken yet. Sentencing is where feeling has to become structure. If it stays feeling, it is useless. If it becomes structure without humanity, it is often waste. I knew the law allowed me a range. I also knew exactly where in that range I was going to land and why. I have not told you the full sentence yet. I am about to. Subscribe before I do because I want to explain every part of it, and the explanation is as important as the ruling itself. Subscribe now. Right before I gave the sentence, the room had a kind of attention I know well. Not suspense exactly, something steadier than that. Daniel had both hands flat on the table, fingers spread as though he was holding himself in place. Ms. Torres had closed her folder but kept one hand on top of it. Sophia was leaning against her aunt's arm, looking at me in the direct way children do when they are tired of adults circling what they mean. I said, Mr. Reed, this court accepts your guilty plea to one count of breaking and entering, a felony of the 5th degree. I find that prison is available under the law. I am choosing not to send you there today. I am placing you on community control for 36 months under strict conditions, because a structured sentence in the community will better repair the harm, better protect the public, and better test whether the promises I have heard in this room are real. The first reaction I noticed was not Daniel's. It was Elena Torres's. She did not smile. She let out one long breath, looked down once, and folded her hands over the closed file. Sophia turned her face into her aunt's sleeve for 1 second, then looked back up at me again. Then I began the parts that mattered most. I said, I am ordering you to pay restitution in the amount of $1,771.67 to Elena Torres. That includes the cash you took, the groceries and medicine you took, the repair to the rear door, and the cost to restore the alarm system. I am ordering it because she should not have to carry the price of your decision for 1 day longer than the law requires. Your first payment is due in 14 days. I said, I am also ordering 240 hours of community service, with at least 160 of those hours to be completed at the Southside Free Pantry on Parsons Avenue, the same side of town where this offense happened. I am requiring that because you took food and security from a neighborhood business, and I want your labor returned to that same neighborhood in a form people can use. If Ms. Torres agrees, up to 40 of those hours may be spent after business hours, helping with cleanup, stocking, or repair at her store. Then I said, you will maintain full-time employment or be enrolled full-time in a certified building trades program for the length of supervision. Within 30 days, you will enroll in the evening HVAC certificate course at Columbus State, because the record shows you already have maintenance experience and need a path to steadier work than day labor has given you. I am ordering this because apology does not keep a child housed. Work does, skill does, structure does. I said you will attend weekly counseling for 6 months, then follow any step-down plan recommended by the counselor with a focus on decision-making under stress, housing instability, and parental burden. I'm ordering this because what happened on January 14th was not only a money problem, it was a judgment problem. Then I said, there is one more thing. On the first Saturday of each month, beginning next month, you and Sophia will complete 2 hours of approved family service together, either at the school breakfast program, a food pantry, or another site approved by probation. I am ordering that because I do not want her only memory of your struggle to be fear. I want one part of this period in her life to be the site of you being useful in daylight. I added one condition that meant a great deal to me. I said if by December 1st, 2026 you have paid restitution in full, completed at least 160 service hours, remained violation-free, and maintained continuous work or school for 12 straight months, I will entertain a motion to terminate community control 1 year early. That was the closest the law gave me to saying what I believed without saying it too plainly. Then I spoke to him directly, and I meant every word. I said, Mr. Reed, what you did was not small. You broke into a woman's business, cost her money she had earned, and added fear to a place where people in that neighborhood buy food for their families. Ms. Torres had to clean up after your choice in the dark and then open her doors the next morning anyway. Do not ever talk yourself out of the size of that. I paused, and then I said the other half. The charges in front of me do not contain all of you either. They do not contain the father who kept a child in school while life was falling apart. They do not contain the man who asked first what he owed. They do not contain the man I believe can do this work if he decides every day to do it. That was the sentence where I named my belief in him plainly. I do not do that lightly. Then I ended with the sentence I had known I was going to say from the moment I wrote down his words on the yellow pad. I said, your daughter has seen enough broken promises. Do not make the court one more person who was wrong about you. Thank you for staying with this story. It is not the kind of story people usually tell about courtrooms. Subscribe if it is the kind of story you want more of. I have more to tell. When the hearing ended, I stayed on the bench for the usual minute while the clerk gathered the papers and the bailiff watched the room settle. What I saw then is one of the reasons I still remember this case so clearly. Elena Torres did not leave first. She stepped toward the aisle, waited until Rachel Kim had spoken quietly to Daniel, and then she said, "Saturday at 8 works better for stocking." That was all she said. Before I stood up, I signed the supervision order with a steadier hand than I had expected to have that day. It was an ordinary act, ink on paper, but it felt different because I knew I was not signing a wall. I was signing a map with consequences on it. Subscribe. I'm about to tell you what happened after the sentence, whether this person did what I believed they would do. Subscribe so you are here for that part. It is the part I care about most. The one later thing I want to tell you about happened on June 18th, 2026. That was the date Ms. Torres filed a written notice through probation stating that restitution had been paid in full 5 months ahead of schedule. On the bottom of her note, under the payment total, she wrote one extra sentence. He also fixed the loose shelf in aisle 3 without being asked. I still have a copy of that notice in the Chambers file. There was no appeal in this case, none by the defense, none by the state. That mattered to me because it told me something simple. The people closest to the facts and the lawyers charged with testing my decision understood what I had done and why I had done it. By the time the school letter arrived on March 3, 2027, Daniel had completed the HVAC certificate, kept steady work with a heating company on the west side, and nearly finished supervision. The principal did not send me a long report. She sent one line about milk crates and breakfast. That was enough. One person doing one useful thing on one ordinary Friday morning. Courts do not often get to see their work in that form. I was glad to see it. If you have ever been in Daniel's position, I want to say one thing clearly. The sign I look for from the bench is not polished regret. It is whether you can hold the weight of what you did without moving it onto someone else. That is what I listen for. If you can do that, bring proof of the life you are ready to build, and then build it. And if you have been in Elena Torres's position, I want to be clear. I never tell a victim what to want. But I have seen that when mercy is chosen freely and tied to firm conditions, it can return something raw punishment sometimes cannot. Not peace on command, something steadier. The sense that what was done to them did not get the last word. That is why I still think about Sophia at the microphone. Not because she made the case sadder, because she made it truer. She did not erase the broken door or the stolen cash. She revealed the pressure behind the bad choice, and once it was visible, my job was not to go soft. My job was to get exact. I opened this story with a sentence about Daniel carrying milk crates before school breakfast on Fridays. I will close it the same way. He still comes early enough to help set out the trays because, as the principal wrote, he says kids should eat before they try to learn. That is why I told you this story. If you want to hear the others, and there are others, subscribe. That is all I ask. Subscribe and stay, and if you leave a comment, leave it as if entering a room where people understand that justice and humanity are not opposites.